If a party loses in the trial court, they may want to continue by bringing the case to the appeals court. But there are several things to think about first. Appeals are expensive and they're time-consuming, and the option to appeal may be limited. For example, if the attorney did not make the correct objections during the trial, or if the client's case does not involve any questions of law, then there will be no basis for an appeal. In an appeal, the court does not bring back all the witnesses and retry the case again. Instead, the court reads briefs written by the attorneys, and then the attorneys argue their case for a short period of time in front of the judges. A case cannot be appealed until a final judgment has been entered by the court. Then the party wishing to have the case reviewed must file a notice of appeal within a specified time period. During oral arguments, the attorneys present their clients' positions. Usually they're given a short period of time, perhaps 20 minutes, to speak. The judges frequently interrupt with questions. The purpose of the questioning is to probe for weak points in the legal arguments. The judges study both sets of appellate briefs. They hear the oral arguments, and then they issue a written opinion on the case. Sometimes not all the judges agree on the majority decision. The other judges may choose to write either concurring or dissenting opinions. You will recall from your reading that a judge may write a separate concurring opinion or dissenting opinion if they want the record to reflect their differences. In a concurring opinion, the judge agrees with the outcome but disagrees with the reasoning of the majority of judges. In a dissenting opinion, the judge disagrees with both the reasoning and the final outcome of the majority. The appellate court either agrees with the lower court's decision, which is known as affirming the decision, or the court disagrees, in which case they will reverse the lower court, or they might send the case back to the trial court for a new trial or other action, which is known as remand. If the party loses in the appellate court, they may try to bring the case to either their state Supreme Court or to the U.S. Supreme Court, depending on the nature of the lawsuit. If the Supreme Court accepts the appeal, then the parties file new written briefs and the appellate process starts all over again.